Section 180 of Companies Act 2013. Hello everyone, welcome back to our channel. Now we are discussing on Section 180. Section 180 acts as a safeguard by restricting certain key decisions. The objective is to ensure that the crucial matters like disposal of assets, large borrowings, and revision of debt are not taken unilaterally by the board, but only with the approval of the shareholders. This is the objective. We'll see statutory framework of Section 180, subsection 1A. Section 180, subsection 1 states that the Board of Directors shall exercise of certain powers only with the consent of the shareholders by way of special resolution. So we'll discuss on disposal of undertakings. Section 180, subsection 1A. Disposal of undertakings. That is to sell, lease, or otherwise dispose of the whole or substantially the whole of the undertaking, or where a company has more than one undertaking, the whole or substantially the whole of any such undertaking. What is the meaning of undertaking? Because the word which is used is undertaking. Undertaking means the investment exceeds 20% of net worth or generates 20% of total income. What is the meaning of substantially the whole? That is 20% or more of the value of the undertaking. Now we will see Section 181B, investment of compensation from mergers. If compensation is received due to merger, amalgamation, or compulsory acquisition, the company cannot invest it in anything other than the trust securities without shareholder approval. And Section 180, subsection 1C, that is borrowing beyond limits. To borrow money where the borrowings, together with the existing borrowings, exceeds the aggregate of paid up share capital, free reserves, and securities premium account. Here is one exception: temporary loans from banks in the ordinary course of business. These are excluded. What is temporary loans? Temporary loans, that is repayable on demand or within 6 months. These are all temporary loans. Then remission of debt due from director. This is what Section 180, subsection 1D. The board cannot waive or give more time for repayment of any debt owed by a director without a special resolution. Now we'll discuss Section 180, subsection 2, that is borrowing limits. Every special resolution under Clause C must specify the total amount up to which money may be borrowed by the board. And there are filing requirement. Section 117, subsection 3Z. Every resolution passed under Section 180, subsection 1 must be filed with the ROC in the form MGT 14. That is within 30 days. Now we will see applicability. The question is whether Section 180 applies to private companies. Section 180 applies only to public companies. Private companies are exempt through MCA notification dated 5th June 2015. Now, if we discuss the interplay between Section 179 and 180, 179 empowers the board to borrow, invest, give loans, whereas Section 180 restricts exercise of some of these powers, requiring shareholder approval. Example, the board can borrow under Section 179 3D, but if borrowings cross the specified limit, approval under Section 181C becomes mandatory. We will also see certain case laws. Larsen and Toubro Limited versus State of Gujarat tell that disposal of assets beyond limits requires special resolution. We'll see another case law, ICICI Bank versus Siggo Leathers Limited. Court held that the shareholders must have the final say in strategic decisions that affect the company undertakings. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest updates. Thank you.